911 was the location of your emergency.
135 Arthur Lane. Please stop, Craig. Please stop.
135. Can you hear me, ma'am? You said 135 Arthur Lane Southwest. It sounded like shots. You still there, ma'am?
A frantic 911 phone call captured Karen Liner's final moments before gunshots rang out. And as authorities started investigating, they quickly landed on her ex-husband, Craig Liner, as their prime suspect. With chilling surveillance footage, shocking testimony, and even a potential confession, there is a lot to unpack, and we're going to break down the disturbing details of this case. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. In the early hours of January 27th, Cleveland, Tennessee Realtor Karen Liner's life was tragically cut short. In a chilling 911 call, Karen could be heard frantically pleading for help, screaming, making a final desperate plea. But moments later, gunshots rang out that would silence her voice forever. The heart-wrenching final moments were captured not only on the 911 phone call, but also on surveillance footage. And it led authorities straight to their prime suspect, none other than her ex-husband, 61-year-old Craig Liner. And this all started early that fateful morning when Karen, at her home on Arthur Lane, made that 911 phone call.
911 was the location of your emergency.
135 Arthur Lane. Please stop, Craig. Please stop.
135. Can you hear me, ma'am? You said 135 Arthur Lane Southwest. You still there, ma'am? I heard multiple shots. It sounded like shots. She's not responding. Are you still there, ma'am?
And the sound of what the dispatcher identified as gunshots echoed through the call. Karen's voice fell silent, and as investigators began piecing things together, all eyes immediately turned to her ex, Craig. He was arrested that same day. He is facing a first-degree murder charge along with a felony murder charge. Authorities say surveillance footage actually captured Craig arriving and leaving that scene in a silver Lincoln MKZ. And even more shocking was what he allegedly told his cousin, Jay Collins, shortly after Karen's death, because he seemingly admitted to the horrific crime. And we're going to get to that in a little bit. By the way, we also checked out Craig Liner on Truthfinder, the powerful background check tool that we use. We can find out information about someone in just a few seconds, and it showed no criminal history for Mr. Liner, but we were able to find details about the jobs that he's held and where he was living. And Law&Crime, we partner with Truthfinder. We use it to get details on people involved in our stories. But even if you don't work in true crime, this can just be an excellent resource to give you some peace of mind, because after all, it's one of the largest public record search services in the United States. And with a paid subscription service, you can get access to unlimited reports about almost anyone. So right now, if you're interested, you can get 50% off of your first month of confidential background reports. Just go to truthfinder.com/LC-Sidebar. Now, although the full details of what drove Craig to allegedly kill his ex-wife, they remain unclear, there are certain key facts and details that have emerged that might give us a better picture. So according to his LinkedIn profile, Craig was apparently a clinical pharmacist at CHI Memorial Hospital in nearby Chattanooga for 10 years, but reporters later confirmed that he had been fired just a week before Karen's death. Court documents reveal that the couple had also been divorced since September, though they shared 2 children. So you have to imagine maybe the combination of his recent job loss and the strain from the divorce could have contributed to the tragic events that unfolded, although that's if you assume that he did in fact commit this crime. He is innocent until proven guilty. So there's a lot more that we have to get into, but before we do that, I want to bring on, back here on Sidebar, crime victims' rights attorney Elizabeth Parker to talk more about this. Elizabeth, thanks so much for coming back here on Sidebar. We appreciate it.
Thanks for having me, Jesse.
What are your thoughts on just hearing that 911 phone call? Because we don't usually get a call like that in a case like this, where, you can actually hear, arguably hear her say, Craig, on the call.
You hear her begging for her life, begging for him not to kill her. It's absolutely chilling and such a crucial piece of evidence. No one can hear that piece of evidence and not be emotionally affected by it and realize just the cold-hearted actions that he took that day.
When you listen to that and you think about the fact that they were divorced for several months, do you think that that dynamic of that relationship, the strain of the divorce, are factors that are being considered by prosecutors and investigators?
I think it has to be a factor. And then, as you pointed out, he had just lost his job the week before. So he had to have been feeling the financial pressure. I think someone in the family said that he was moving from a house to an apartment. And you have to think that this factored into, you know, the divorce being so recent, so close in time, his ex-wife moving on with her life, with his kids in a different house, had to play a factor along with losing his job.
Those are potential triggers. Do you see those in a lot of domestic violence cases?
We always see this in domestic violence cases. Certainly when the victim moves forward and moves on with their life, the perpetrator never wants that to happen. And you always see them taking revenge. And then financial hardships constantly are a piece, financial piece, however it is. And you have two children, so you assume he's paying child support. You assume he's paying some sort of alimony. Maybe he lost a house. You know, we don't know the details of the divorce yet, but that all had to have played a factor here.
And it moves me to what I want to talk about now. So there was this preliminary hearing and bond hearing that was held on February 21st, and we got a lot more details about this case. And essentially, by the way, for anybody who doesn't know, prosecutors have to present sufficient probable cause to move forward with the charges. And this hearing, again, revealed a lot more disturbing details about the case. So, for example, you have a detective from the Cleveland Police Department, Don Nation, who testified that surveillance video from neighbors' homes showed Karen screaming at Liner when he arrived at her residence, allegedly uninvited. And although we didn't see the footage, the detective testified that he could see Liner allegedly start shooting.
Can you tell us what did the individual in the video do after Miss Liner's body falls to the driveway?
From the video, it appeared that he stepped back into the garage for a few seconds. It looked like, from what I could see, he had bent down, unsure what he was doing at that moment. He then walks back out of the garage and appears to sit in the driver's seat of the white sedan that was in the driveway. The vehicle is started. After a few seconds, he then appears to step out of the vehicle and shoot at least one more time.
Elizabeth, that is so significant. The idea that he fires or allegedly fires one more shot after getting out of the car. So I wanted to ask you about the defense and what a possible defense could be. But one of the struggles we have, one of the struggles a defense attorney would say, maybe something was in the heat of the moment. They couldn't control their actions. But if there is a pause in shooting, that defeats that claim, right?
Absolutely. I mean, he goes to leave, starts up the car, according to what the judge states. We couldn't really see in the hearing what was on the video. But the judge states that he gets into the car, he starts up the car as if to drive away, and then just to make sure that she's really dead, takes one more shot. And we don't know. We know she was shot 3 times in her shoulder, I believe, in her head. She's definitely bleeding from the head, and in her chest. So we don't know which shot was first. But we know. And
just to be clear, can we definitively say that extra shot he took or allegedly took was at Karen? Did he shoot her, or was it a shot somewhere else? I couldn't confirm that.
I don't think we can definitively say that.
Okay.
Maybe there'd be some expert down the road that can say the trajectory of the bullet and the angle of where it shot. Could that have been the fatal shot? We don't know at this point. There are some experts out there that can do those things, but we know that he made sure she was dead.
And let me emphasize something here, and I'll emphasize something the prosecution emphasized, that not only had Karen been fighting for her life, but also they wanted to make it clear that this was a surprise attack, that she did not want him there, did not expect him there. How so? Take a listen.
You can see the garage door closing, and then the defendant scurries and ducks under the door so he can get into the garage, even though Karen is actively closing it. And we all heard on Exhibit 1B, the 911 recording, her telling him to get out and that he couldn't be there, and screaming and fighting for her life. So the state would submit that there has been ample proof that Ms. Liner did not consent to that man coming into her garage.
Now, I will say maybe the most chilling moment came during the testimony of Craig Liner's cousin, Jay Collins, who I mentioned before, because he recalled an apparent conversation he had with Liner just 15 minutes after the shooting.
And he said, well, it's over. I said, what are you doing? It's over. I said, what do you mean? I finished it, or I was in a state of shock at that point. I was like, what?
Okay, Mr. Pond, so would it be, is it your testimony that he said something to the effect of, it's over, and something to the effect of, I finished it?
Something like that.
Okay. Did you ever ask him what he was referring to, what he finished, or what was over?
Yep, and he said, like I said, it's over. Or I was like, huh?
Do you recall if at any point the defendant told you that he had taken care of my problem or taken care of a problem?
That's the way I took it.
Okay. And what did you take the problem to be? What was the problem that he took care of? What was finished?
Well, I figured it was his ex-wife.
And Collins also shockingly testified that Liner asked him to hide firearms at his home, including a .40 caliber pistol. So, Elizabeth, first of all, no hearsay issues here? He can just testify as to what his cousin told him?
It's a statement made by the defendant that's admissible. You could tell in the hearing he's a little bit uncomfortable. He doesn't want to really be there. The state, I'm certain, subpoenaed him. He did reach out to law enforcement because he was concerned, but he's a little bit vague when he testifies. He says that Liner says, well, it's over. I finished it. I took care of the problem, things along those lines, but he couldn't be very specific about what Liner said. And he assumed, or he said, I think his testimony was, I figured he was talking about his ex, Karen.
Is that a confession? Do you see it as a confession?
I think you can twist it certainly into it being a confession. It's certainly an admission against interest. I think the defense can turn it and try to say, well, he never told you that he shot Karen. He never said, why he did it. He never told you where he came from. You assume that's what he was talking about. But listen, you have the video surveillance. We know he was there. It's circumstantial that we know now this is a confession. This is an admission from him. He even said the type of gun that he used. He said he used a .40, which we all know is a .40 caliber. Now, I haven't seen any ballistics reports to line that up to show that that is, in fact, the gun that he used, but I would assume that that's consistent.
Why would somebody admit a crime like this to a family member? I mean, you've seen it, I'm sure, in your practice. I've seen it here on Law and Crime. Is it that they need to just, assuming he did this, right? Assuming he did this, is it that they just need to get it off their chest? They're trusting somebody? I mean, why? Who would admit a crime to somebody like this?
It seemed unusual to me. Everybody talked about Craig Liner's emotional disposition at the time at the police station and his cousin right after the crime, that he was unemotional. He was unaffected. I think that may come into play here. I don't know if the defense is going to say that he'd had a break with reality and he didn't really know what he was doing and use some sort of mental defense. I'm not sure, given he lost his job. We don't know why he lost his job. He was a pharmacist. I mean, I think there's a lot of speculation out there about it, but it seemed to me he had already put this plan in place. He had already talked to his cousin about hiding these guns at his house. He'd already had the car that he used in the commission of the crime hidden at his cousin's house. So I think he trusted his cousin enough to think that he's not going to say anything and he's not going to go to the police on my behalf. That's what it seemed like here to me.
I'm struggling with the defense, and I want to get into that. First, I'll let everybody know that at the conclusion of this preliminary hearing, Judge Clay Collins decided that the case would be referred to a grand jury, that it would move forward. Craig Liner is going to remain in custody without bond. But, you know, Elizabeth, I am struggling with the defense. You know, first of all, insanity, right? I looked it up under Tennessee law. It's an affirmative defense to the prosecution that at the time of the commission of the acts constituting the offense, the defendant, as a result of a severe mental disease or defect, was unable to appreciate the nature or wrongfulness of the defendant's acts. My personal take, I don't think it applies here if he knows what he told his cousin and allegedly was trying to get him to hide weapons, and that, you know, I don't know if that, I don't think it applies. But I was also wondering about voluntary manslaughter, which my understanding in Tennessee is the intentional or knowing killing of another in a state of passion produced by adequate provocation that is sufficient to lead a reasonable person to act in an irrational manner. But that doesn't justify going to somebody's house and killing them, right? I mean, even if you are consumed with emotion and anger, that's not enough. And especially if you're the one who started the altercation, I don't think that either of those apply, right?
I agree with you. I think the mental health defense is a stretch. I did find it interesting that the defense filed a motion to recuse this particular judge very quickly and very early on in the case. You know, sometimes the strategy is the evidence is overwhelming, so let's just make sure we have our ducks in a row and make sure we have something to use on appeal.
It's an interesting twist because Liner's defense raised concerns about potential bias due to the claims that the presiding judge, Judge Clay Collins, had ties to the victim, Karen Liner. So they filed a motion asking for Judge Collins to recuse himself or step down from the case. I want to actually play a portion of that argument.
I know Your Honor told us on the conference call that you didn't have a personal relationship with Ms. Liner, and I totally believe that. There are connections, however, that make it personal for Your Honor. For instance, when you look at the, if I may approach, you may. Exhibit 1 to this hearing is a print-off from the Rotary Club of Cleveland's post about the very incident that Your Honor is tasked with making crucial decisions on. In that post, many mutual friends that Your Honor has on social media have shared the post and made comments, and some of those are attached to that. Whether Your Honor can be neutral and detached at all is not our issue. With those posts and those strong, real-life club and social media connections, I think puts Your Honor in a position to recuse.
Now, Liner's attorney pointed to a social media post from the Rotary Club of Cleveland where members expressed sadness over Karen's death, and Judge Collins is a member of that group. But the judge clarified that he didn't personally know Karen Liner, denied the motion for recusal, ruled there was no conflict of interest. Elizabeth, is that just too simple? Should this have been assigned to a third-party judge to look at this? Do you think that there's some sort of connection here that the judge would have to recuse himself?
You know, Jesse, I looked at Tennessee law, and there's even case law out there that talks about a judge being friends on Facebook with a witness that testifies in front of them. And the Supreme Court of the state of Tennessee said there's no problem there. So here, I thought it was interesting because the judge quickly asked the defense attorney, well, do you know how many members there are of the Rotary Club? And the defense attorney sheepishly said, I don't. And he says, well, there's about 150 members. And then he asked how many people lived in the county in which he was a judge. And he said, you know, I have 53 followers on Facebook. I'm a public profile. So they're not friends of mine. They're actually followers. And the judge stated in no uncertain terms, if I had had any qualms about my ability to be fair and impartial in this matter, I would have recused myself from day one. He made it clear he didn't know Mrs. Liner. He made it clear he didn't know Mr. Liner. He'd never had a conversation with any of them. And he said that the tenuous argument that the victim's boss was friendly with the judge and had actually, I think, been his sponsor to join the Rotary Club didn't affect him in any way, and that he could be fair and impartial. He was very, very clear on that. And I agree in him denying their motion to recuse, but I think this is just strategy to create an issue for appeal because the evidence is very, very strong against Mr. Liner that he'll be convicted. I mean, obviously he is innocent until proven guilty, but there's overwhelming evidence that we see already against him just at a preliminary hearing.
It's a great point. It's a great point. And I will say this, look, the judge, as I mentioned, decided to refer this case now to a grand jury. How does it work now? How does it work in terms of the grand jury's role in all of this and how the case progresses?
So the grand jury will basically look at all of the evidence, and the state presents a very short and sweet and tight case to the grand jury. And they'll issue an indictment on, whatever charges are presented in front of them, whatever they think the evidence supports. There's always kind of a joke out there that a grand jury would indict a ham sandwich because basically, the prosecution is the only one allowed in the grand jury. They're the one presenting the evidence. It's their version of events. So I don't see the grand jury not returning what they call a true bill on both of these counts, meaning that they will indict on both of these counts if the evidence that was presented in this hearing is presented to the grand jury.
Now, there's another issue that happened as well. So it wasn't just the issue in terms of was there enough evidence to move the case forward? It was also an issue of bond. So I want to talk about what happened during Craig Liner's first court appearance. So this was back on January 30th when his attorney initially made his argument that Liner should be granted bail. And he claimed that typically bail is provided in all different kinds of cases, including maybe a homicide case, even those involving first-degree murder, and that the prosecution hadn't sufficiently shown why Liner should be denied bond. Take a listen.
It wouldn't be fair to the defendant, from our perspective, to deny bail or bond, waiting on hearing proof from the state. It's a bailable offense. You can grant bail, as Your Honor saw in homicide and first-degree homicide cases. We did an analysis of the last 10 years of Sessions Court cases, and that information is in our motion. There are bonds set anywhere from, I think, $20,000 or $50,000 up to $1 million. We'll take from Your Honor the chance that you revoke the bond or raise it after a hearing. But as he sits before Your Honor, he's entitled to bail, and that's our position. Because, just as Your Honor said, you haven't heard any proof. The defendant has the burden of proof on certain things. We just went through that with the recusal motion. The state has the burden of proof on other things. There's no aggravating factors been proved, Your Honor. In fact, no proof before Your Honor. This is a bailable offense and a bailable defendant, and we ask that Your Honor grant him bail.
Now again, this was before the official bond hearing, but prosecutors, they painted a much darker picture. They stressed that Liner is charged with a capital offense and that family members were expected to testify, which added weight to the argument that he should be held without bond until further proceedings, that it was too premature to prevent any sort of, maybe intimidation or witness tampering. I want to play you this because Liner could also face the death penalty if he's convicted.
As far as being entitled to have a bond, that's just not the case with a capital offense. He could get a bond, but just as he could get a bond, you have the ability to decide that he should not get a bond because it's a capital case. So I don't think that factor is really in the defendant's favor. But speaking of rights, the victim's family has a right to be heard at the bond hearing. That is a right that is guaranteed in the Constitution as it applies to victims of crimes, and they have indicated, at least partially, that they are very much considering testifying via the request that we discussed during our phone call this past Friday. So the state's position would be that this defendant needs to be held without bond until we have a preliminary hearing and or a bond hearing, as the state has been ready to do that since January 28th.
And in the end, the judge decided to deny Liner's bond. Elizabeth, what do you make of this? Can you explain why the judge came to this decision? Is this the right decision in this kind of case?
Well, when setting bail, or we call it bail in some states, or bond in Tennessee, the judge has to consider the defendant's criminal history, clearly the seriousness of the charge, and their ties to the community. The goal is to ensure the defendant appears in court without being overly punitive. Here in a capital case, or let's just call it a first-degree murder, the punishment you're looking at is either life in prison or the death penalty. So the punishment is severe, and the likelihood that a defendant is not going to show up in court with those kinds of charges pending over them is very great. But what the state argued, and in fact, the judge went over the evidence and his finding to find probable cause to take the case to the grand jury and deny bond, is he said a couple of things I thought were interesting. He said Liner took a car that he doesn't regularly drive that day. The 911 call clearly tells him not to come into the garage. The garage door, you can see, the judge states on the video that it's coming down, and that that's done by the victim. She takes the garage, or she presses the button to put the garage door down, and Liner actually blocks it so that the garage door then goes back up. He forces the door up. He enters the garage. He shoots her. The judge states the home is solely owned by her. And why that is an important fact is because you can't burglarize a home that you own or you jointly own with another person. He says there's one gunshot, then there's a pause, then there's three more. He said, the judge said she's screaming, she's begging for her life after the first shot. She falls out of the garage onto the pavement, and then we know he gets into the vehicle, starts it, and then 10 seconds, the judge even timed how long it took. 10 seconds, he gets out of the vehicle and shoots that final shot. And there's the three shots that actually are what contributed to her death. And then he drives back to his cousin's house, and we know what he says then. Right. So what's interesting is that in order for there in Tennessee to be a capital murder, you have to have one of 19 aggravating factors. And here the state is arguing that the killing of another and the commission or attempted commission of a burglary is what justifies, or that's one of these aggravating factors. And so a burglary would be entering into a home without the consent of another, either to commit a crime, and here we would have an assault, or here he shoots and kills her. So the judge clearly found that there was a burglary, that Liner was committing a burglary, which is an aggravated factor, which could be then a capital offense and could constitute the death penalty. So based upon that, the state's position that it was a capital offense, that the evidence that the judge reviewed, he supported his decision to hold Mr. Liner no bond.
Do you think a jury would agree that this warrants the imposition of the death penalty?
In Tennessee, yes. Many other states, no, but I think in Tennessee, based upon the aggravating way that this crime took place, the premeditation, oftentimes you don't have video evidence to see. It's going to be so impactful to a jury,
and the 911 phone call.
And that 911 phone call, to hear her last words, to hear her begging for her life. Oftentimes you have just a detective coming in saying, this is the way the crime happened, and it's kind of unemotional. Here, the jury is going to see this homicide, this first-degree murder in real time as if they were there. That's impactful. There's no way around this. I can't see a defense here.
It's so interesting, because so many times I say, it's hard to imagine what their final moments were like or their final words, and here you have it, and it's incredibly bone-chilling. I will say, though, I am curious in terms of mitigation, right? So when we rate aggravating versus mitigating factors in terms of defense, you mentioned the hardship he might have had in his life, divorce, losing the job. Here's something else to think about. So the Chattanoogan reports that in November of 2016, Craig Liner's parents, Max and Sue Liner, they were found dead inside of their Cleveland home for an apparent murder-suicide. They were both reportedly in their 80s. They reportedly had health problems, and the outlet said it was Craig who was the one who discovered their bodies. So, Elizabeth, while I don't know if that necessarily is going to play a role in the actual trial per se, I do wonder, a traumatic event like that, again, assuming he committed this crime, coupled with everything else we talked about, possible mitigation?
Possible mitigation, absolutely. Oftentimes in these death penalty cases, you have more than one aggravating factor that warrants the death penalty. I can see that being a mitigating factor. Oftentimes you have psychologists, psychiatrists, they'll go back to, the early stages of a person's life, and this is what affected them and the trauma. I can see that being a focus feature of any mitigation, and if they're trying to convince the jury not to give him the death penalty. Anything that can evoke sympathy and give some sort of excuse for his behavior is what the defense is going to focus on in mitigation.
No, 100%, 100%. And look, we're not at that point yet. We'll see how it progresses. But let me end back with Karen for a second. So the Realty group that Karen had previously been a part of, they posted a tribute to her. And the post included a goofy, candid shot of Karen with her coworkers at a United Way event. And the post reads, "We are devastated at the loss of our dear friend and colleague, Karen Liner. This picture embodies Karen's joy, zeal, and charisma." The post continued, "Karen was not only a fantastic member of our team before she started a successful solo career, she was the best friend we could ever ask for. Karen was larger than life, joy-filled, quick with a smile, always positive, always encouraging, organized, driven, and our biggest supporter and cheerleader. Karen always chose to take the high road when things got difficult. We aspire to always work hard to be more like Karen." And as for Craig Liner, the case set to move forward, with the grand jury due to meet on April 28th to decide whether this case will go to trial. For now, he remains behind bars without bond. Elizabeth, thank you so much for coming on. Really appreciate you taking the time, and just fantastic research and analysis into this. We really appreciate it.
Thanks for having me, Jesse.
All right, everybody, that's all we have for you right now here on Sidebar. Thank you so much for joining us. And as always, please subscribe and check us out on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.